Hi, welcome to Been There Done That. This channel is all about employment tribunals, everything you need to know and how to represent yourself. This video is all about the overriding objective, a term you will need to become very familiar with if you plan to represent yourself at tribunal. This is basically the whole point of the whole court and you will want to refer to it a lot. So let's get going. So the overriding objective is a term that is used very frequently in an employment tribunal, and it's used to remind everybody why we're here. And it's not just why you and the respondent are there that day, it's why the court exists and it's why the process exists. The overriding objective is built into the rules of an employment tribunal. It's actually the second paragraph within those rules, and it sets out the main fundamental reasons why these rules exist and how they can then be implemented. The overriding objective of the Employment Tribunal Court is dealing with a case fairly and justly. Now, in order to describe that, they break it down into 5 little categories. So let's look at each one in turn. Category number 1. In order to deal with a case fairly and justly, you first have to make sure that both parties are on an equal footing. What that means is no party has got the upper hand, no party has got an advantage. In order to make that possible, no party is allowed to have a communication with the tribunal that they haven't copied the other party into. You can't send evidence to the court without copying them in, and they can't send evidence to the court without copying you in. If you want to make a request for something like a strikeout or a preparation time order, you have to copy them in. Fairness involves both parties seeing all the information. It also involves things like when you give each other your witness statements, there is a date for that to be done so that you both transfer on the same date and nobody has somebody else's witness statements for days and days and days and then has the upper hand because they know what you're going to say and you don't know what they're going to say. It also involves things like the bundle preparation being a team effort. You have to work together and agree that this bundle of documents is everything that you both plan to rely on in court, and then that is given to all parties way in advance of the actual date. In order to be on an equal footing, everybody needs to be able to see everything and there are no surprises and there is no access for one party that the other party doesn't have. The second part of dealing with cases fairly and justly is dealing with cases in a way that is proportionate to the complexity and the importance. So what that means is it's not going to be a 20-day hearing with 400 witnesses if what we're talking about is a missing bonus payment of £20. So they always need to be weighing up the significance and importance of each case in order to treat them fairly and justly. The third tier to the overriding objective of dealing with cases fairly and justly is not having any unnecessary formality and trying to be as flexible as possible. This actually became quite apparent in my case because at the time of my case I was breastfeeding a 7-month-old baby, and the whole plan for the court case was that it would be cloud-based because we were right in the middle of the early stages of the coronavirus pandemic. The respondent demanded that it be in person. It would have been inflexible of the court to force it to be in person, and that would therefore have made it unfair. The fourth step is avoiding delay so far as is practicable. Obviously, if there are delays upon delays upon delays, people's memories can fade, witnesses' evidence can become less reliable, documentary evidence can be harder to locate. So generally speaking, we try and avoid delays as far as is practical and in proper consideration of the issues. It might be that a delay is unavoidable because you just can't have the hearing without that one person and that one person is away. And that's completely unavoidable and it needs to be considered as fair and just. And the fifth rung to this is saving expense. So in order to deal with all cases fairly and justly, they need to bear in mind that there is a cost implication behind some of the decisions that they might make. So you might save expense by not having an additional preliminary hearing that you don't really need, but actually just dealing with unresolved queries via correspondence. Sometimes all 5 of these, or several of them, interplay with each other. So if someone was requesting an extra preliminary hearing to discuss a minor point, you think, well, is it proportionate to the complexity to have an extra hearing? Would it be extra formality? Is it going to cause a delay? Is it going to be expensive? Well, of course it is, because you've then got to have the judge and the panel and the lawyers and everyone in for another hearing. So they will consider all of those things, or some of them, or one of them, when making every decision that they have to make. Uses for the overriding objective when it comes to you is reminding people about it while you're in court and while you're dealing with things like the bundle and any other correspondence. If you feel that the respondent is doing something like time wasting or withholding evidence or asking for evidence that is irrelevant and it's going to cause you an awful lot of ordeal and hassle to get it, maybe they're asking for something that's too personal for you to share. If you find yourself in circumstances like that, you can bring up the overriding objective. You can pick whichever one of those points you think is most relevant, and you can either write to or speak to the judge depending on where this conversation is taking place, and you can say, in the interests of the overriding objective, I don't think we should blah. So let's say they're asking you for a medical report. They want you to go to see your doctor, book an appointment, have them assess something about you, and then have a report written and have that report submitted. Well, you then need your doctor's time, you'd have to make time and go and do it. Then you might have to pay for a report, because I don't think that sort of thing comes under the NHS. And obviously all of that is possibly going to cause a delay. So you might then want to go back with, in the interests of the overriding objective, I believe that this would be an unnecessary formality, that it will cause a delay, that it would not be in the interest of saving expense, etc., etc., etc. So familiarise yourself with the overriding objective and those 5 key parts of the overriding objective and use them to make sure that justice is served for you. I hope you've enjoyed this video and I hope it has helped. Please like and subscribe, check back, comment, all of that lovely stuff, and I'll see you on the next one.